Now, good evening to all of you. I am extremely sorry I was delayed because of my own university web meeting was going overboard and I had no time to even intimate you. So I rushed it, concluded it and came to this webinar. Luckily I am within the time and I am happy Shailesh has taken the initiative and that's what I was also supposed to say about Girish Ramachandra Deshpande. So there is no disagreement with him, but then I would like to give some details. Details, the devil lies in details. Everybody knows that. Some people positively say God resides in details. I don't know whether it is devil or God. We will discuss details. Now, Girish Ramachandra, what kind of a damage it has caused to us is a known factor. Everybody knows that it has a very, very serious impact on the disclosure of information. Now, as a commissioner, I have experience because I was facing all kinds of defenses from respondents using Girish Ramachandra Deshpande case. Everybody, if I post 25 cases a day, you believe it or not, in 20 cases, respondents plead, Sir, Girish Ramachandra Deshpande. We have used the office memorandum and Girish Ramachandra Deshpande, finish. So, in legal circles, there is one interesting expression. That is, there will be one decision of Supreme Court that will silence everybody, generally speaking. And before that Supreme Court judgment, nothing works. And it is called pocket pistol decision. Pocket pistol. That means you can simply take out the pistol from the pocket and shoot out the request. It is called pocket pistol decision. Then I have made a presentation on Girish Ramachandra Deshpande saying that everybody using Girish judgment as pocket pistol decision. But I said it doesn't have bullets in it. Then I said, what is it? How can a pistol be without bullets? I said, yeah, because it is dismissal of SLP, it doesn't qualify to be a precedent. That was my stand since beginning, which Shailesh also was telling it, but I am using some technical expressions, legal expressions, but he was using common sense and common language that was more appealable. What he says is, it is not a full-fledged reasoned order, so it is not precedent. But I'll give you legal support to it. I'll prove that it is how Shailesh is correct and how it is not a precedent. I'll prove that. But before that, we should see what exactly, I don't know whether Shailesh covered what exactly the RTI request points of Girish and how they were rejected. Was it covered? Or should I briefly mention it? Okay, I'll briefly mention it. He was asking for appointment order of A.B. Lute, some officer, which is running 3 pages. And then he was also asking for the salary details of A.B. Lute. Then salary details they rejected. Look at fundamental flaw here. The PIO committed fundamental flaw. 81J doesn't come over here at all. Remuneration being paid to public servants is at point 10 of 41B. If you have an act with you, you can check up later. So 41B, small Roman 10, X, small Roman X, says that remuneration that you are going to pay to public servants have to be given on your own. So an information which is supposed to be given on own cannot be affected by section 81J or 81 at all. 81 is not attracted to 41B. 41B and 81 are mutually exclusive. We should understand this point. I gave this in many of my orders. I explained this. Okay. Then second is again the granting enforcement officer promotion to, some promotion was given to that officer. He wanted to know what is the salary of the promoted position. That also was denied using the same. Then again there was a demand for show cause notice copy, censure issue to officer. Censure issue is issued to officer. Understand? Censure means what? There was an allegation, there was an inquiry, it ended with a censure. That means when the code of conduct related disciplinary case was entertained by the concerned public authority, there was a conclusion, and that conclusion says that you deserve to be censured. That means there is something wrong committed by him. Wrong committed by public servant means the parties who are affected by public servants' wrong action is public. So public are related, public interest is related. It is not your private performance, it is your official performance, and in your official performance you are found faulted and then you are censured. How can this become a personal information relating to employer and employee? That is the question. Okay. Then the copy of EPF that was given 60 pages, that was no problem. It was a stop and condition rule. Copy of return of assets, and you know the difficulty with return assets and liabilities. Even today we are struggling whether copy of assets and liabilities of a public servant can be disclosed or not. In spite of Lokpal Act, in spite of several decisions, in spite of so much of agitation by Anna Hazare and all that, Lokpal and all that, nobody follows the Lokpal Act. And Section 14, Venkateshan will be right person to talk about this. He has fantastic material with him. So the assets and liabilities is a big question with big controversy. They think that as if they are giving their assets and liabilities. In fact, what is being asked is information about it. They think that they are giving assets and they are transferring the liabilities. It is not the case. Okay. Then copy of report of item wise and value wise details of gifts. Here I would like to say one thing to you. According to Code of Conduct, there is a clear case that you cannot accept a gift which is more than value of so-and-so money. And that value is yet to be revised. Somewhere it is there 50 rupees, somewhere it is there 100 rupees. In some states it is 50 rupees. Long ago it was written as 50 rupees. So now you have to report to the officer, higher officer, if you have accepted a gift which is valuable more than 50 rupees. That is the rule in some places. Somewhere it is 100 rupees, somewhere, and you tell me nowadays which gift anybody will take if it is below rupees 500. Even a beggar may hesitate to take. So it's a question of conduct. If you accept gift and somebody is asking for the item wise, value wise details of the gifts, what happened? He says it is a private information, cannot be given. That is point number 8. Then 9, movable and immovable properties of lute, and that was also rejected. Then TADA claim, they said they are not claiming that. That's also gone. Point number 11 they gave. Point number 12, they wanted certified true copy of charge sheet issued to lute. The matter pertains with head office, so it was transferred. Look at this. A very crucial information is asked. He was charge sheeted. Charge sheet copy, everybody is asking, and charge sheet copy was not given, but it was transferred on 6 subsection 3. Now, neither the High Court looks into this matter, nor the division bench looks into the matter, nor Supreme Court bothers about, and CIC never bothers. That's a tragedy, I tell you. It's a tragedy. And when you have transferred, the CIC should have directed the transferred PIO to give this information. It doesn't do it. Okay. Now, they say it would cause unwarranted invasion of privacy, all that you must have discussed. Okay. Now, copies, memorandum, show cause notice, everything is rejected. They said there is no larger public interest, and finished. Now, there is a CIC, while dealing with they quoted their own full bench order. I don't know whether Shailesh is with the commission at the time, I don't know. Milap Churaria versus Central Board of Taxes. They say income tax return have been rightly exempted from disclosure personal information. That is one point they were using. Then they say I have no hesitation in holding that this information also qualifies to be the personal information. That is the conclusion of Girish Ramachandra Deshpande, CIC. Now it goes to single bench. Dharmadhikari, he sits in Nagpur, 2009, petition filed by Girish. Dharmadhikari says that finding of CIC on larger public interest is not demonstrated to be perverse. So it is not perverse, it is correct. I therefore find that no case is made out by the petitioner warranting any interference in exercise of writ jurisdiction. Finished. Then it goes to division bench. Now, before it goes to division bench, he says there are no allegations of any corruption practice or other similar activities to say that such disclosure will be in public interest. This is the factual wrong. In the first CIC level, I showed how the CIC ignored legal provisions. Now here High Court ignores factual position. There are charges, there is an inquiry, there is a censure, there is a charge sheet, and you say because there is no charge made, it is not public interest. Though it is on the face of it, it is not correct. Okay, looking to the nature of the document, it is apparent, they say personal and they reject it. In fact, there is a charge sheet, one should note down. Then it goes to division bench, D.D. Sinha and Bhangale judges, 2 judges. They simply repeat what single bench judge has given, and then they proceed further. They quote Surup Singh Naik case, but they don't agree with it in this context. Then against this, now look at what happened. I have to give you some inputs about general law. If statute provides for appeal, you will go in appeal. If statute doesn't provide for an appeal, you have to take a leave for appeal from the High Court. That is called LP, leave permission for going an appeal, SLP. Special leave petition. So leave petition, if High Court rejects, then the party has a provision under Indian Constitution. If he feels that some judge or some commissioner or some authority has done injustice to him and his fundamental right is violated, he can approach Supreme Court and file a SLP. SLP means special leave petition. LP is before High Court, SLP is before Supreme Court. Now, Supreme Court says SLP. First point is, it is dismissed. Now, whether it is dismissed with reasons or without reasons, answer is, it is dismissed with reasons, because he gave 6 or 7 pages judgment. Whether it was a full-fledgedly argued case, it is not. Is it a full-fledged appeal? It is not. Then what is it? It's a mere petition for permission to filing an appeal, because Supreme Court thought that there is no issue of national importance for which we can take up the appeal. They are rejecting. So that is their conclusion. They have every authority to do that. Absolutely, we are not questioning the authority of Supreme Court. Supreme Court can dismiss SLP in limine with 1 word or 3 paragraphs or 3 pages or 4 pages. It can do. But what is the impact of dismissal of SLP? That's what we have to look into. Dismissal of SLP will not render the judgment of Supreme Court the value of precedent. There are several judgments which form precedent to say that this is not precedent. Now, nobody can go into techniques of these things unless you are a researcher or a lawyer. You will not come out with this. So I remember in one of the meetings in Delhi, Shailesh was asking me, Professor, how to get over this Girish Ramachandra. That is the starting point of my investigation, and I'd like to tell you, with that with that I wrote this book. This book which says, is bribing a family affair. Somebody takes a bribe, somebody asks for a question, and you say it's personal. What does it mean? Is it a family affair? Something related to progeny, family, making a family, marriage, or delivery. Is it a case of a delivery, a pregnancy? What is it? So this is the book I could write because of question of Shailesh Gandhi. And nobody published it. Very interestingly, nobody came forward to publish, because I was criticizing Girish Ramachandra Deshpande, Radhakrishnan and Deepak Mishra's judgment. Nobody came forward to publish. So I published it on my own. I collected some money from some friends and they published this book. Okay, fine. What I am trying to tell is, it's a deep-rooted matter and it cannot be SLP. Then what happens if it is not SLP? I'll come to that. Then Supreme Court talked about all this same old stuff. It was repeated, and then said, performance of an employee officer in an organization is primarily a matter between the employee and the employer. And normally those aspects are governed by the service rules, which fall under the expression personal information. I am really surprised to know how service rules is private information. It's terrible. And I would like to tell you, the moment you are working officially, you are not a person. And all your office related work is office work. It is not private work. Even if it is not a public office, suppose you are working in a private organization, you are working with them, and you have generated so much of material documents in that in that office. Tell me whose information it is. Is it your private information, or does it belong to the office where you are working? Common sense says, where you are working, it belongs to that. I am now working in a university. I develop a resolution. I propose a resolution in academic council. Academic council accepts or rejects it. Is it my personal information or university information? Simple, it's a university information. Similarly, when a government officer works in government, when he generates some information, it is his information. It is office information and not personal information. And I have a wonderful criticism against the official secret expression also. Now, it is a oxymoron. Official, secret. If it is official, why should it be secret? If it is security secret, I understand. If it is official, how can it be secret? If it is personal, it can be withheld. But how can it be? So these are the problems we face day to day in this. So they say this government, this Radhakrishnan and Deepak Mishra, great judges, they delivered wonderful judgments in my understanding, separately. But jointly, this judgment is really terrible. And I don't know, it doesn't have a factual stand, it doesn't have legal stand, it doesn't have a constitutional base, and it doesn't even answer to the common sense. Very, very unfortunate judgment of these two persons. I tell you, this also, I was quoting this judgment in my research LLD work. I'll show you that work also. This is my LLD work, where I said privacy is being used as secrecy. Here I analyzed the judgment of Supreme Court on privacy and said how it damages disclosure and public interest. I explained this. For this I got LLD in 2018 from National Law University, Visakhapatnam. That's a different story. Then I wanted this, this was published when I joined Bennett University. And when I wanted this to be released. Then my friend wanted to ask Deepak Mishra ji to release it. Then I said, please don't do it, because I have written a commentary on his judgment. He may not like it, and it is not proper on my part to ask him. So that is the difficulty I face. Okay. Now this judgment, what he says is, you please read this sentence. What Shailesh gave you is a broader aspect, but I am taking you to micro analysis of the sentence given by the Supreme Court in this case. Of course, in a given case, if the Central Public Information Officer or the State Public Information Officer or the Appellate Authority is satisfied that the larger public interest justifies the disclosure of such information, appropriate orders could be passed. But the petitioner cannot claim those details as a matter of right. This is absolutely wrong. I agree that larger public interest gives you a scope for disclosure of the information. To that extent, I agree with you. But you cannot say that it is not a matter of right for the petitioner. It's a matter of right for me because it is guaranteed by the statute. I come to you, you are a PIO, I'll say, sir, there is a larger public interest right. I have a right to plead that. And you have to, burden is on you. Now you know, sir, what is that? RTI Act specifically says, the burden of proving the justification for the denial of information. That you are right in invoking a provision from 8.1, lies on PIO, lies on public authority, not on the petitioner, not on the requester. So tell me, sir, is it a matter of right of a person or not? So factually, legally, on basis of common sense, Supreme Court's paragraph, this paragraph is absolutely not correct. Okay, now we'll go to the question, this SLP dismissed. Now first I'll narrate the history of the events, and then I'll go to how SLP dismissal is not a precedent. Though I would like to give you some more justification to that point. Okay, then what happened? Then there was another petition for information of similar type that was rejected. First appeal rejected, reached CIC in 2013. Mr. Satyananda Mishra, Chief Information Commissioner, dealt with that case, and by that time Girish Ramachandra is available. Girish Ramachandra is quoted as a precedent. I can't expect every information commissioner to be thorough with SLP dismissal, whether it be precedent or not. I'm not sure. In fact, I was also not thorough with that until I did research. So I don't blame anybody here. I don't blame my colleagues. Maybe he thought because Supreme Court, 2 judges have given an order, Supreme Court judgment will definitely apply or can be enforced all over the country. He might have genuinely thought that it is a precedent. Okay, that is the problem with the Supreme Court. Whatever they say, it will become a law. Okay, then what happened? He gave an order quoting Girish Ramachandra Deshpande, this information cannot be given. Now look at the consequence. I'll deal with this later. This is the AThis Memorandum on 14th August 2013. So-and-so number, if anybody is interested in knowing number, please note. And it was issued by Ministry of Personnel, Public Grievances and Pensions. Okay, 14th August, AThis Memorandum. What does it say? The Central Information in one of its decisions has held that information about the complaints made against an officer of the government and any possible action the authorities might have taken on those complaints qualifies as personal information within the meaning of provisions of 81J of the RTI Act 2005. This may be circulated to everybody. Now, what does it mean? Don't give. Do you know what is the I don't know whether I can use that word. It's a fraud. It's a fraud on RTI. Do you know what is kind of fraud? Section 81J within itself contains larger public interest rider. And 8.2, section 8.2 in my view is a fantastic section. 8.2 covers all the subclasses of exceptions under 8.1. Whereas 8.1J, public interest, is confined to only three aspects. Larger public interest is an overriding exemption to exception only in three clauses of 8.1. Whereas comparative public interest, which is delineated under section 8.2, covers each and every provision, each and every clause, each and every exception. And the office memorandum conveniently deliberately omits larger public interest override, 8.2 comparative public interest override. I am summarizing 8.2 as a comparative public interest. I'll tell you what 8.2 says. 8.2 says, if the interests of the parties are better served by non-disclosure, don't disclose. If the interests of the party are better served by disclosure, disclose it. So, by way of public interest. So, they wanted the CIC, they wanted the First Appellate Authority, they wanted the CPIO to examine whether if I disclose it, what is the harm? If I don't disclose it, what is the harm? They have to compare. Suppose harm against disclosure is serious than the disclosure, don't give that information. I am fully with you, don't give. But if harm is lesser than the harm caused by non-disclosure, disclose it. That is the section 8.2 should have been actively used by the information commissioners at the center and states. That would have solved the problems of the people. Well, that was suppressed by this memorandum. This is the fraud of the memorandum. This is the illegality of the memorandum. And you know I'll tell you what is the importance of office memorandum. According to law, office memorandum is a subordinate legislation. Doesn't have any value. Over it is law. Above it is constitution. So this is the order. Now, suppose there is an office memorandum in one place. There is a parliamentary enactment somewhere. Which one will prevail, sir? Parliamentary enactment. Okay. There is an office memorandum and Supreme Court judgment. Which will prevail, sir? Supreme Court judgment. But nobody knows what is Supreme Court judgment. Nobody knows. It is not circulated. It doesn't reach the people. Nobody reads your commentary of 5,000 pages on RTA. Nobody. So it is difficult for them. Do you remember there was a sexual harassment judgment in 1996 or 97 in Vishaka case by Supreme Court. But there was no law. Somebody went, after reading the judgment, a woman went to police station and complained, "Sir, I am sexually harassed." Then he asked, under what section of IPC I have to book a case? No, Supreme Court judgment case. No, I cannot book a charge case under Supreme Court judgment. I cannot. So he rejected it. In fact, he called me in Hyderabad. Professor Saab, boliye, मैं क्या करना? Then I said, you have to register a case. But show me which section. I could not. I said Supreme Court judgment. So Supreme Court judgment really is a precedent, I agree, but doesn't have enforceability, practical enforceability. For that, law has to be made by the Parliament. And Parliament did not make law until 2013 or 2016. They did not make law. What to do? That is, of course, another tragedy. Now, in the absence of Supreme Court's the value of precedent or any other order, you have issued a memorandum. It will have a complete effect. Who is a PIO? PIO is a servant. In a central government, PIO is a servant who is bossed over by DoPT. And DoPT issues a circular. Do you think he will not obey it? He will simply obey it. And that is the dangerous, what is it called? It's a blade, guillotine. Do you know what is guillotine? Guillotine means cutting out faster. It's a machine to cut. So all the RTI requests are guillotined at the level of PIO, at the level of First Appellate Authority. It will reach the Commission, and if Commission is not aware of the lack of precedential value to the SLP dismissal, he will also simply follow. So what is happening at every stage? Every PIO, every RTI application rejected by PIO will not reach First Appellate Authority. Every rejection of First Appellate Authority doesn't come to CIC. And if it comes to CIC, you know what is happening with the impact of Girish and this office memorandum. So that is the problem. Now, let me explain you the law of precedent. Under Article 141, law declared by Supreme Court shall be binding on all courts. So this is also explained. But what are the material factors of this? It has three aspects. A finding on material facts. That means material facts, not on technical points. It should be a finding on material facts, which Shailesh was telling just now. Then principles of law applicable to legal problems disclosed by facts. So your facts and law should be matching. Now I told you how many places the law and facts are not matching in Girish case. I told you. They say there are no charge sheets, there are no charges, but I show there are charges. So that's a missing point. There is a larger public interest override nobody looked into in a particular case. But of course in Supreme Court they say there is no larger public interest. To say that there is no larger public interest, they relied upon absence of charges. But I am telling you there are charges. In fact, very RTI application and its rejection shows that there were charges. So what are we doing? You are not looking into facts, you are not looking into law, and you pass a judgment. Then 136, SLP, the power of SLP is under 136. It's an extraordinary power. It is called extraordinary power to grant special leave of appeal. So it can admit a case which is not otherwise admissible. It can take appeal, though it is not applicable, and then deal with it. And they consider if it is possible that there is the matter of national importance is going to be decided, take it. If you think that there is no such material question involved in it, reject it. They rejected it. SLP of Girish was rejected. Now, if SLP is accepted, writ appeal is taken, both the parties are heard exhaustively, and then judgment is pronounced. That will form precedent under 141. But rejection under 136 is not precedent. If full-fledged hearing happens and judgment is given, that judgment, the lower court judgment, merges with the Supreme Court judgment, and Supreme Court judgment becomes precedent. That is called doctrine of merger. Okay, these are the decisions which say that the precedent, how the precedent has to be calculated. This is another judgment. In 2010 also this principle was accepted by Supreme Court itself. I am not explaining you because there are cases. Anybody who is interested, I will share it. You can read it. Now, Girish is not a precedent. Girish, Supreme Court is not a precedent, but High Court is a precedent. High Court judgment in Girish is a precedent. It will apply where? It will apply in Maharashtra. It doesn't apply in Delhi. It will not apply in Andhra Pradesh. It will not apply in Haryana, because High Court's power is within the state. Okay. And whether it applies in Maharashtra, that's a different question we have to decide. In Maharashtra, you have another case, other cases which do not agree with Girish. So those when two division bench judgments are there is a division bench judgment here, there is another division bench judgment is there. Then you must look to a Supreme Court judgment. Shailesh must have already told you about R. Rajgopal. R. Rajgopal is a very, very excellent judgment. Even today it is valid, and that says this information which is denied by all these persons is not deniable, it is disclosable. So which judgment is precedent as on that day? Judgment of Supreme Court in 1996 in case of R. Rajgopal is the valid precedent. And what did he say? Any information with reference to home, family, marriage, motherhood, procreation and child bearing. These are the areas of private information of public servant. I am telling you, public servant also has privacy. I agree. But what is his privacy? This is his family, wife name, the son's education, daughter's age, name and details, so on and so forth. You can't ask these questions. You don't ask these questions. Then R. Rajgopal talked about assets related information is a public servant of a public servant is a public domain. That is the Lokpal. That is the judgment of Supreme Court. Delhi High Court in 2009 in Subhash Chandra Agarwal's case. I'll talk about it very briefly immediately. And there are some more cases which talk about privacy. I'll skip them. Then these are another cases. This is another case. And then State of UP versus Rajnarayan says anything that is about that is related to public transaction is not private. 1975. The State of UP versus Rajnarayan is a bench, and we simply ignore it. Okay. Now you have a problem with assets and liabilities. Supreme Court has approved in 2002 in ADR case. Jagdeep Chokar must have talked about it. He says the information about assets and liabilities of every contestant is not a constitutional authority. Contestant is a private person. If he is elected, he will become constitutional authority. So even at the stage of contesting, your information should be made available. Fine. Then second level, you become MLA or a minister or MP. The information about your assets of your spouses and dependents also become relevant. I'm not saying it. Supreme Court said in Union of India versus Association for Democratic Reforms. And read the order, read the sentence. There are widespread allegations of corruption against the persons holding post and power. In such a situation, question is not of knowing personal affairs, but to have openness in democracy. I am not interested in knowing private affairs of a member. I am only concerned with corruption. That's all. For attempting to cure cancerous growth of corruptions by few rays of light. That was the conclusion of Supreme Court in this case. Then I will take you to another case, PUCL versus Union of India. The question was whether assets and liabilities information of spouses is also private information or public information. Do you know what Supreme Court said? The fundamental right to information of a voter and citizen is promoted when contesting candidates are required to disclose the assets and liabilities of their spouses. That is the public interest. So it is in tune with your section 81J. In tune with. So it says that it is not private information. Supreme Court ruled that when there is a complete competition between the right to privacy of an individual and right to information of the citizens, the former has to subordinate it to the latter right. That means what? It overrides. What overrides? RTI overrides privacy of an individual. I'll tell you, if some criminal, somebody committed a crime, murder, his telephone call details contain the details of communication with the persons in arrangement for committing murder. Now, tell me whether that telephone conversation details, number details, is it a private information or public information? Generally speaking, telephone data is private. But you are a criminal. You have committed a murder. You have contacted various persons 1 hour before murder to prepare for murder. And that will give me scope for investigating you and putting you behind bars. Public interest, larger public interest. You have to give that information. Okay. Then Puttaswamy. Now, so far I was arguing with you that Girish is not a president. It is an empty pocket pistol, but empty. Now the Supreme Court has supplied bullets to it. How? In Puttaswamy case, with mentioning Girish Ramachandra Deshpande as the opinion of the Supreme Court. My objection is mention itself is not correct. When it was SLP dismissal, why should you quote it? You should have quoted R. Rajgopal, you should have quoted another case. But why did you quote Girish Ramachandra Deshpande? I don't know, and my Shailesh friend doesn't know, and you do not know that it is not a precedent. But Supreme Court judges know that it is not precedent. When it is not precedent, why did you quote? And the mere quoting of Girish Ramachandra by Puttaswamy gave value, increased value of precedent to Girish Rama. That is the problem. Now, okay, what this Puttaswamy effect is, we have to say it is Puttaswamy effect, very serious effect. Invoking the right to privacy to deny information related to assets of public servants and income tax returns of citizens is extremely problematic given the publicly admitted high levels of corruption and widespread tax evasion in India. It is not part of the judgment. It is one of the contentions. I am just quoting it before you. I wrote an article after that judgment, after that privacy judgment on the impact of RTI. So that's a different thing. Parliamentary, do you know what is the impact of Puttaswamy? Parliamentary Standing Committee is requesting the Election Commission to revise the requirement of spouses of candidates to make public details of their income, property details, invoking Puttaswamy case. Now look at that. We have not only destroyed the RTI under statute, the Girish is going to have effect through Puttaswamy to effect 2002 wonderful greatest judgment of Supreme Court, which gave us right to know about assets, liabilities of contestant and his wife also. So this is the problem. This is the harm that it is going to cause. Now, one of the essential aspects of Girish is performance report is not public information. Now I am asking you, what performance the citizen is interested in? Not his performance at home, not his efficiency in washing the dishes. We are asking his efficiency about his efficiency in public office, public activity. And how can that be a family information? This also lost the sight of these judges. In a democracy, why not people know the performance of the public servants? And that is the essence of accountability. The ability of the public to monitor the suitability of critical appointments at the state and central levels requires that people have access to information regarding the performance, experience and appraisals of public servants. Performance includes charge sheet. Suppose somebody is charge sheeted for a dozen times for corruption. Can you pick him up for a higher position? Can you select him as an election commissioner? Or can you select him as information commissioner? You should not. That is the reason why the performance of appraisal is available there. Appraisal performance is there. We are not at all looking at it. That is the tragedy. And I'd like to tell you, there is one more wonderful judgment on November 13, 2019 in Subhash Chandra Agarwal's case. Subhash Chandra Agarwal has asked whether you are implementing a past resolution that judges of Supreme Court and High Court would submit their assets and liabilities reports to Chief Justice of India. He is not asking for the copies of assets and liabilities. He is asking how many judges submitted, how many did not. Suppose they gave 28, 17, some figure. 28 judges gave, 17 did not. There is no case for Subhash Chandra Agarwal. There is no case. But they refuse that also. They fear the fear of RTI. RTI is so powerful because even Supreme Court feared it. That is the power of RTI. Okay. Supreme Court denies it, coming to CIC. CIC accepts, CIC I think asked for disclosure of information. This is a reverse of Girish. In Girish, everywhere it was rejected. But in Subhash case, everywhere it is accepted. Except PI1 First Appellate Authority, who are none other than Supreme Court people. And then, do you know what is the title of the case? You will be wonderful. It will be wonderful to know. It is not Subhash Chandra Agarwal versus Supreme Court. It is Supreme Court versus CIC. Supreme Court versus Central Information Commission. As if Central Information Commission has committed something wrong. And then it goes in appeal to High Court. High Court says in division, in single judge bench, give the information. You have to give this information. Who says? High Court says to Supreme Court, give the information. And then Supreme Court files an appeal, letters patent appeal, saying that I don't give information. It is personal information. I will not give information. And what Delhi High Court division bench says, Supreme Court give the information. And then Supreme Court files a case before Supreme Court. Do you know against whom? Against Central Information Commission again. Very interesting title. Then the judgment comes in 2019, November 13. I rate this judgment as a very, very seriously harming judgment to Right to Information Act, because it has again confirmed the Girish Ramachandra Deshpande, restricted the scope of information and widened the scope of restrictions. This is unbecoming of legally speaking, constitutionally speaking, it is not correct. Because their own judgments earlier say that scope of information has to be liberally interpreted as expandable, and scope of restrictions have to be strictly interpreted so that it doesn't gain extraordinary interpretation and widen the scope of refusing the information. There are several judgments of Supreme Court, and I think if me and Venkatesh sits, we can bring out so many judgments of that. Okay, and Supreme Court conveniently ignored it in its wonderful judgment dated November 13, 2019. And what was the issue? The issue before them, whether the information asked by Subhash Chandra Agarwal has to be given or not. Instead of confining to that, they gave a commentary on entire RTI Act, entire commentary, a very big commentary, as if they are writing a book like Shailesh Gandhi and Sridhar. They wrote a book. And what is that book? How does it operate? It operates as an office memorandum of DoPT. It can operate. I don't know whether they got the idea of doing it. I hope nobody gives them idea of doing it. So today it says TPIO should think like this. This is the scope of this section. This is the scope of that section. This privacy has to be adopted. In privacy, you have to adopt the judgment of Girish Ramachandra Deshpande. That's what it says. Terrible judgment. Then it reduces the scope, I told you just now. The verdict also restricted the understanding of the terms held by, under the control of. Today we have an issue of PM Cares Fund. Now there is one expression available in public authority definition, that is control. And you know what kind of a control it should be? Parliament did not say complete control, deep control, extensive control, substantial control. It did not say all this expression, simply said control. But you know, the great Supreme Court in Talapalam case said it should be substantial control, deep control, complete control. Why do you bring in all these things? Now, let us say, who has control over PM Cares Fund amount? Who has control over decision making? Who has control over allotment of funds? Who has control over changing the criteria? Who has control over the officers dealing with the fund? It is PMO, PM and PMO. Now tell me, is it public authority on this point? It is public authority. But they say, no, we are not a public authority. Now look at I just give you one paradoxical point of refusal of PMO to give information about PM Cares Fund. Information was asked from PMO. PMO is a public authority. Public authority PMO created PM Cares Fund. They should give that information, huh? But do you know what they say? No, we created PM Cares Fund, but PM Cares Fund is not public authority, so we don't give the information. You are public authority, you should have given the information. They don't talk about it. I wrote an article in Live Law. Yesterday it was published on 4th or 5th. If you have time, please see. Then Parliament has reduced the stature of CIC, and partly I was blamed because I gave some orders which they thought the CIC is very powerful, and because of that they reduced the power of CIC. That's another tragedy. I am not going to details of that. The damaging paragraph of Supreme Court judgment number 13 is paragraph 59. Paragraph 59. Do you have time? I have 3 more slides and I can finish. I hope I have time. Reading of the aforesaid judicial precedents would indicate that personal records, look at the 59, the dangerous 59. Personal records, including name, address. Name is personal information. Can we understand this? Can anybody live in this world without disclosing the name here? Name is private information. Address, physical, mental and psychological status are all treated as personal information. Similarly, professional records, including evaluation reports, disciplinary proceedings, all are personal information. Now, where is Girish Ramachandra Deshpande? All argument of Shailesh Gandhi. It is not a precedent. It is not decided based on reason. Gone. Finished. A bulletless pocket pistol is replaced by AK-47. This is AK-47. All are personal information. Now go to the next point. Medical records, information relating to assets, liabilities, income tax returns are personal information. Finish. Assets and liabilities, you cannot ask. Lokpal Act, gone. Nobody's personal information can be asked after this judgment. Nobody's medical information can be sought. Nobody's disciplinary proceedings can be sought. Nobody's performance appraisal can be sought. That is the judgment. Now look at the last point. Such personal information is entitled to protection from unwarranted invasion of privacy, and conditional access is available when stipulation of larger public interest is satisfied. And look, see this last sentence? This list is indicative, not exhaustive. That means in second judgment it will give some more points. In some more judgments will come and some more additions will be made. So Supreme Court has really damaged it. But there is one hope. Don't get disappointed totally. I'll give you one hope. What is that hope? That larger public interest. Nobody can remove that. Even if 100 Supreme Court judges with full benches sit over our head, they cannot kill larger public interest. So I say every RTI activist, every commissioner, every advocate who advocates RTI, simply establish larger public interest under 8.1 and comparative public interest under 8.2. And you will be winning and you will be entitled to information in spite of this damaging judgment. And that's where I say RTI is still alive. You can't kill it. You are trying, but you cannot. Okay, then I explained this and I have added some more aspects. And immediately after Puttaswamy, do you remember Canara Bank case? Worst case in Indian judicial history. It says transfer related information is also private information. That is the damage. Okay, I'll conclude my presentation with this wonderful statement of James Madison, given long ago. He's the 4th American president. What does he say? Knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power which knowledge gives. Thank you very much.
Thank you so much, sir. That's amazing and very